Welcome. We're glad you could join us today on our last event for National Crime Victim Rights Week. We'll be sharing the things that don't make it into crime and courtroom dramas and that you may not be aware of. We've assembled many advocates today and asked them to share information with you. We want you to know the faces of some of the people who work tirelessly behind the scenes to help crime victims. Some housekeeping issues. If everyone could please turn off their cell phones and their electronic devices as we're recording and live streaming. We've provided you with paper and pens to write down any questions that you may have while your presenters are speaking. We'll come around and collect those from you when we take a break, about halfway through, and then at the end we'll address those questions. We're asking you to hold all questions until after all the presenters speak. Let's see. Thanks for joining us today, and our first presenter is going to be Laura Kalt, and she's going to talk about what happens after an arrest is made. Laura?
Good afternoon. So my name is Laura Kalt, and I'm one of the victim advocates that works with the Gainesville Police Department in partnership with Alachua County Victim Services and Rape Crisis Center. And I have a lot of information to cover in a short amount of time. I have kind of a flow chart that's going to help me out here and give you a visual so you can follow as I'm speaking about this. I'm going to be covering what happens when a report's made. So of course, we have typically a victim who initiates a police report, but it can be another party. Sometimes we have a witness or a friend or family member of a victim who might make contact with the police to initiate contact and start an investigation. So patrol is going to be the first responders. They're the ones who are going to show up. Patrol officers are typically in a police uniform and are easily identifiable. They'll be in a patrol car. They will begin the investigation, getting important information. They're looking to get, of course, important players in the crime to understand the who, what, when, where, why kind of questions, answer those types of questions. So there's a lot of details, a lot of information. Of course, officers who are first responders are the ones who are also tasked with rendering aid to a victim if they're injured, setting up any kind of, crime scene tapes and things like that to make sure that they preserve any evidence that might be there on scene. So there's a lot that a first responding officer is going to be thinking about and taking care of. They're going to be relaying information back to other officers so that there can be communication back and forth, and more officers can show up if needed, and that kind of thing is going to be taking place. They also will make a decision of whether a detective will need to be called out. So our detectives divisions, these are our plainclothes officers. These are people that usually will show up in a suit or, not in a uniform. But these are part of the police department or part of the sheriff's office, and their role is to do a more long-term investigation. So sometimes detectives will show up on scene and begin an investigation and help patrol, and it'll be actively pursued by patrol officers and detectives. So if you're looking at the flow chart there, I have where it starts out with a contact made to the police department, and then we have patrol investigations, and then the investigation continues by the detectives bureau. So patrol will make a decision of whether their investigation is completed and whether things will end when they're leaving scene, or whether the investigation will be continued with detectives. So someone might initiate a call to the police. It may be that an investigation takes an hour or two and things are completed. It may be that that investigation is going to continue with the detectives division for many days, many weeks, sometimes even months, depending on the type of case. But essentially, after either patrol or detective is finished and completed with their investigation, we're getting to a decision. The patrol officer or detective is making a decision: do they have enough evidence, do they have enough information to make an arrest? If they do, they're going to make that arrest. If they feel they have a strong case, but they're not quite ready to make an arrest, they can file what's called a sworn complaint. So that's going to be where they write up their investigation, they write up their report, have all their evidence there, their photographs, whatever else they might have compiled during their investigation. They're going to turn that over to our state attorney's office. So that would be a sworn complaint, and the state attorney's office will pick that up. Or, of course, they might just close out the investigation without an arrest or without a sworn complaint. So sometimes that does happen where we have a case that's unsolved, or where the unsolved type of case where on the end where I'm talking about cold case, those may be more serious crimes, sexual battery, homicide, where we do not have a suspect identified. So those might go into kind of a cold case mode, whereas some cases will be completely closed out with no further investigation. Sometimes that'll be a suspect was never identified, or for some reason they were unable to gather enough evidence to make an arrest or file a sworn complaint. Moving on, once an arrest is made, that defendant will be at first appearance within 24 hours. So they're going to be before a judge within 24 hours. That judge is going to make a determination of how much their bond will be set at. So they'll be given special conditions potentially of if they do make bond, whether they can have contact with the victim. A lot of times in our cases, we're going to see at first appearance, the judge is going to be setting a bond and then also saying, do not have contact with the victim. Maybe check in with court services. So the judge has some decisions to make there. We have our state attorney's office and our public defender's office who are at every first appearance to help the judge make a decision based on information that the judge may need from either office. After first appearance, the state attorney's office investigates. Some people assume that once an arrest is made that the state attorney's office really has nothing more to do except do the attorney work in court, but there's an investigation that begins. So that includes interviewing every victim in the case, interviewing every witness in the case, reviewing all the evidence that the police has handed over. And the state attorney's office investigation, I have down in the next box after that testimony. Testimony is kind of an important one for victim advocates to talk about with victims. That's when the victim is going to have their testimony. So that's their chance to talk about the case with the attorney, with the state attorney handling their case. They will be relaying all the facts of what happened and going back over what happened. But part of that meeting is also for the victim to be able to have a chance to ask questions and get an idea of what to expect from here. So testimony is going to be taken by the state attorney, and witnesses will have their testimony taken also. You can see the sworn complaint box leads down to the state attorney's office investigates. So going back up, the sworn complaint was where I was talking about the officer or detective determines they're not going to make an arrest. They do want the state attorney's office to investigate to see if a court case can go forward. So a sworn complaint is going to go to the state attorney's office, and they're going to hold testimony. So the state attorney most likely in every sworn complaint case is going to hold testimony with the victim, witnesses, do the same kind of investigation they were doing with an arrest, but there's not been an arrest made yet. So the state attorney's office has a decision to make. Do they file on a case or do they not file? If they file, that means they're going to file the information. They're going to put forth to the court that they plan to proceed with the case. They call it information filing. So that is, the state attorney's office will do that with an arrest or a sworn complaint. After they investigate, they're going to make a decision. Are we going forward or not? If they go forward, they're going to file that information. And with a sworn complaint, that means that person is going to be arrested. That means they are going to have a first appearance, and it'll continue on the same track from that point forward as an arrest would have gone. Off to the side, I have closed without further action. So again, like with the police, the state attorney's office can review an arrest case or a sworn complaint case and decide we don't have the information we need to be able to sustain a conviction. We don't have the information we need to be able to go forward. So at that time, they would not file the information. They would close out the case without further action. Continuing on, like I said, I have a lot to cover, and there's a lot of other speakers. I have a box that's called hearings, arraignment, case management, bond reduction hearing, pretrial hearing. So I've just kind of named some of the standard hearings that happen in most cases. Some cases will maybe have multiple case management hearings, or may not ever have a bond reduction hearing. A defendant has a right to request for their bond to be reduced, and some don't. Some don't ask for that. But these are potential hearings. Most are pretty standard, pretrial hearing. Some cases will be resolved once they get to this point. You know, at some point within that process, a case can be resolved before it goes to deposition. So that's our next box down, deposition with defense. Some cases will be resolved by the state attorney's office before they get to a deposition. Other cases will go to a deposition and then resolve, or go to a deposition and have a trial. So when I say resolve, I'm thinking of cases where we don't have a trial and we have what's called a plea bargain process, a plea agreement. So you have your state attorney office and the defense attorney that come to an agreement about what a sentence should be. So that is something that the two parties agree to. They show up to court. We usually call it a change of plea hearing. And so we would go before the judge, and the judge would listen to both parties, understand what the agreement is, and the judge would be the final person to decide whether that agreement is legal. Everything seems appropriate with it. And if the judge signs off on it, then our case is resolved without a trial. So deposition with defense, that is when the defense attorney holds depositions, meaning they will have their chance to interview any witness and every victim in the case. They have a right to do that if they choose to do that. Victim advocates can be present, and I haven't kind of mentioned the role of a victim advocate yet through any of this, but a victim advocate can be present. Some of these, like a deposition with a defense, it's actually in the Florida statutes under Florida 960 that allows for a victim advocate to be present during a deposition. Other times, a victim can request for a victim advocate to be present, and absolutely most of the time victim advocates are present. But at deposition with a defense, it's actually part of the Florida statute that a victim advocate can be there. So again, that's just an interview with a defense attorney. It is recorded. It's something that there'll be a transcript of that interview. Moving on, then we have. I was talking about change of plea. So below defense, I put it there, change of plea, but it can happen before a deposition. And sometimes we have change of pleas that take place pretty quickly, but most of the time we have a change of plea being, 6 months into a case, maybe 9-10 months into a case. So I have explained that a little bit. I'll talk about a trial. I think we all kind of have an idea of what those are, but that's where you have a jury who's going to hear both sides of the case, and the defense and the state are going to put forward their information and make their case before a jury, and a judge is going to be present. So during a trial, you have your victim, you have your witnesses, you have anybody that has information, you have your police officers who've done their investigation. You may have analysts who have done lab work with testing forensics that are involved in a trial. Pretty much anybody that's going to help prove the case is going to be asked to participate in a trial. And below that, closed without further action or sentencing. So change of plea is, like I said, that's where both parties have agreed to what the sentence is going to be. So sentencing and change of plea sometimes are interchangeable terms. We might call it a change of plea hearing, but basically most of the time they're sentenced on that hearing date. A trial, sometimes, of course, we have to get a guilty verdict for there to be a sentence on a trial. Those would be the others that go to closed without further action. If we get a not guilty verdict, then we're going that route. But if we get a guilty verdict, we're going to have sentencing. So sentencing is a time where a victim can speak up and be heard and has a right to talk about how the crime has impacted them. They call that a victim impact statement. So at sentencing, the state gets to put forth to the judge what they feel is the appropriate sentence. Defense gets to argue what they feel is an appropriate sentence. Victim gets to speak, and actually the defendant will get a chance to also present information, whether that be witnesses or character witnesses or people that they want to have speak on their behalf, as well as sentencing. And the judge will be making a decision on sentencing. And that is kind of a very quick run-through of what might happen if a person makes a police report. And I think what we're going to do is hold off on questions until the end, so thank you.
Thank you, Laura. Our next presenter is going to be Jennifer Lawrence. And Jennifer Lawrence is a victim advocate with Gainesville Police Department and the Alachua County Victim Services and Rape Crisis Center. And she's going to talk to us about a program called VINE today. Thank you.
Good afternoon. My name is Jennifer Lawrence, and I will be talking today about VINE and exactly what it is in detail. So, Florida VINE stands for Florida Information Notification Every Day. So what exactly is VINES? VINES is a free service that allows crime victims to learn the custody or court status of an offender 24 hours a day and is available 7 days a week. This can be done through telephone or internet. Victims can also search for information and register to receive telephone and email information notifications whenever the status of a offender changes. VINES is available, it's anonymous, it's accessible, it's free. Oh, I'm sorry, and it's free. And it's also available, it's monitored and it's also available in multiple languages. So why is VINES important? Because it's your right. Nobody asks us to become a victim of violence. So it's your right to be notified, to be informed, to be heard, to be treated with dignity, to be treated with respect, and to be provided with information about your case. VINE is currently available in 46 states and in over 40 departments of correction. I'll go back so you can just see the states that it's provided in. It's also available locally through the county jail. So when the officers come out, they will present you with a form, and it asks, do you want to be notified when the suspects are released? So these are the available states that it is available in. These are some important facts about VINES, and it just gives you a little bit more information in terms of how data is collected. So information about the suspect is going to be collected every 15 minutes, and calls for notification are made every 30 minutes until answered, then every 2 hours until it's confirmed. So basically, it's going to continue to call you and call you and call you to get your attention until they've made contact with you to let you know what's going on with the case. And this is going to happen for 24 hours. So you're going to continue to get called, like we said, every couple of minutes until you confirm that they've received that information. So the information, to make sure that the information is correct, they're going to ask you to put in a PIN code, and that's also going to be how you will make them aware to stop calling you, I guess. Some important VINE facts are sometimes the jails register people without telling you, and so because you won't know that they've done that, for your PIN code, it's usually going to be the last 4 digits of your phone number. If you have a phone that's usually, well, sometimes gets turned off, or you're not sure how it's gonna, if it's gonna be turned on, maybe use a family member's phone number, or if you're working with a victim advocate, you can use their phone number so maybe they can be notified, and then they can notify you as well. Like I said, the PIN code is usually the last 4 digits of your phone number, and when they're calling, once you enter this code, confirmation has been received that you have received the phone calls and the notices, and then they will stop for that the most recent updated information with your case. So how does Vine work? Excuse me. It brings awareness, it brings access, registration, events, and notification. With the awareness, victims can learn about Florida Vine information from victim advocates. So you can ask, if you're working with a victim advocate, you can ask your victim's advocate about the program and how it works, and they can give you the information for that. Law enforcement officers can also provide that information at the scene. The media, presentations like this where we're informing you and we're letting you know how it works, and then also the public education, again, like what we're doing, and just bringing awareness about the topic. So the access part of it, you can look up information online. You can do it via the telephone, via the internet, and then you can also call the Vine operators, and they will provide the information for you. You can register to be notified by telephone if you do not have a working telephone or don't have access to one. You can also register by email and to receive letters in the mail. So you'll be notified anytime a change in the offender's custody status occurs, which will initiate the notification. If you are getting calls, don't automatically assume that he's getting out, he or she is getting out, or that something has gone wrong. When you receive a call, it may just be that they've been transferred to another jail, or that something, again, is going on with the case, but just don't automatically assume the worst. If you still kind of are a little confused and are not sure what's going on, you can always call your advocate to get the most recent details. Or you can go online and look it up to kind of see what's going on with your case. And again, notification occurs 24 hours a day, 7 days a week, 365 days of the year by telephone, email, or a letter. And then again, once you put in your PIN number, then they know that you have received the message about the most updated information. So you can access Florida Vines. It's statewide by calling 1-877-VINES for Florida. And again, that's 1-877-846-3435. And then there's also a link for it. Okay, is that it? Thanks. Okay. Yeah, there you go.
Thanks, Jennifer. Our next presenter is going to be Yolanda Thompson, and Yolanda is with the Attorney General's office, and she's going to speak to us today about victims' compensation. Welcome, Yolanda.
Good evening. It's a pleasure to be here. We're gonna get started. Okay. We're gonna briefly get started with victims' compensation. It's like squeezing a gallon of lemonade into a little itty bitty lemon is about this presentation. It's so much information that I could give you about it, but for time purposes, we're only going to talk about victims' comp in general. The other components of victims' compensation is property loss, domestic violence relocation, sexual assault forensic examination, as well as sexual battery relocation. I would encourage everybody to go to our website, which is myfloridalegal.com, and to view these other components of victims' compensation. Who is eligible for victims' compensation? Anybody who receives physical injury as a result of a misdemeanor or a felony crime committed by another adult or juvenile. It also includes psychological injury as well as, personal injury or death that may not, psychological injury that is not sustained as personal injury or death would also qualify for the mental health counseling piece of it. And a lot of times that can be viewed as armed robbery. A person didn't receive any physical injuries, but the mental impact of the event has physically, crippled them in some capacity. Okay. Minors who suffer psychological or physical psychiatric injury as a direct result of witnessing a crime. And we have a lot of cases like this dealing with domestic violence. A lot of children witness one of their parents being abused, and it affects them psychologically as well. They would be eligible possibly for victims' compensation. How the process works is the crime must have occurred in the state of Florida and have been reported within 72 hours or establish a good cause to why not. And a lot of examples that I give for the good cause, it could be that the person stole the victim's personal identification and has threatened to come back and retaliate if they report that crime. The application must be filed within 1 year from the date of the crime, or 2 years for a good cause. And I always tell everybody the good cause is that this is a hidden secret. There are numerous people, I would say a vast majority of citizens that live in the state of Florida that have no clue that this is available to them if they have been victimized. The Florida Statute 960 defines criminal acts committed outside of the state against a resident of Florida. So if a person is in another state and they're victimized, there's a possibility that they could apply for the Crimes Compensation Program here in the state of Florida. However, we always tell them that they have to start with that state's crime compensation program. And we also let them know that every state's crime compensation program does not mirror our state. So what that means is that the services that we have available here in Florida might not be the same services in Georgia or in Texas or in Virginia. If a person applies for another state's crime compensation and is denied, we ask them to send us the information to show that they did apply with that state, and then we will start our process to see if they're eligible through our Florida Crime Compensation Program. They have to cooperate with law enforcement, the state attorney's office, and the attorney general's office in order to be eligible for crime compensation. The victims at the time could not be engaged in any unlawful activity upon the crime that they're applying for. The victim or claim must not have been in custody or confined at the time. So the people that are locked up are not eligible for crime compensation. The victim or claimant must not have been adjudicated as a habitual felony offender, habitual juvenile offender, habitual violent felony offender, violent career criminal, or adjudicated guilty of a forcible felony offense. That's a lot of information. So pretty much it's saying that if they have committed any other compensable crimes on any other victims and now they have become the victim, they are not eligible through our program. These are the program benefits that we cover through crime compensation. We take care of medical, mental health treatment, wage loss, disability, catastrophic disability. We also take care of funeral burial expenses, loss of support, grief counseling. We have a priority sequence that we follow. We take care of funeral burial expenses first, then we look at economic loss, and then we look at out-of-pocket expenses. And then we take care of treatment expenses. However, at the bottom, please note that any victim or applicant can request that a particular bill or a particular item be paid that is not in this particular sequence order. So what that's saying is that if they have medical insurance on their job and they know that they don't have any benefits that will cover them for being out of work, then they could say, will you take care of the lost wages? And we will do that. We also explain to them that once we pay, whether it be funeral, burial expenses, or medical expenses, it's considered a debt paid in full. And I encourage people to go to our website because we have a cap as far as with our benefits. So that means if a $250,000 bill comes in, we're not going to pay $250,000. So I like to let people know that that's how the process of our payout. Crime victim exemptions, deductibles and copays. Crime doesn't have a certain day of the week that hits or a certain time within the hour. So a lot of times victims are victimized, January the 1st. Well, a lot of us, our deductibles and copays renew on the 1st of the year. So they have not met those. We do not want a victim to miss out on getting medical treatment because they can't meet that deductible. They can't meet that copay. So what we have put in place, and it's under the Florida Statute 624128, is a insurance waiver. Excuse me. This insurance waiver pretty much lets the service provider know that they can bill us for the deductible or they can bill us for the copay. We have a lot of victims or a lot of service providers who will not accept this insurance waiver. And a lot of times it's because people are not aware of it. They have not been educated on how it works. So we ask that the victims or the victim advocate report this to us so that we can possibly give them a call, explain the process to them, send them this waiver that we administer so that they will be able to assist the victims. This next piece is, I'm going to speak with you briefly about how you can apply for victims' compensation. What a person will do is they'll go to our website and they will look under application for victims' compensation. They will print this application out. They need to make sure that it's legible when they fill it out. They need to make sure that they provide their social security number, date of birth, address. We ask that a complete packet comes in when you send in your application. And what a complete packet means is that you have the law enforcement document, you have the law enforcement report, you have the application, as well as any medical bills. And I understand that a person might be victimized on Monday, they're seen in the ER, that medical bill probably has not been generated by the time that they're discharged. So we ask that, as those bills come in, that they send them into the Bureau. We ask that the bills come in and they be itemized. We act as an insurance provider as well. So in any cases when you send in claims to your insurance company, they're looking for those billing codes to make sure that it's something that's eligible. And what we also look at is those codes as well as apply those codes to the victimization, because that's the only way we will pay out on a medical bill is that it has to be related to that particular crime. You can submit the applications 3 ways. You can mail it, you can either fax it to any one of those 4 fax numbers, or you can email it. I always encourage people to email it. If you have scanning capabilities, email it to vcintake@myfloridalegal.com. If you don't, fax it. And I also encourage to fax it and maybe call. I'm the regional advocate for the 4th and 8th Judicial Circuit, so I encourage people that instead of call Tallahassee because they get bombarded every day with hundreds of phone calls, you could always call my local office. If you contact Tallahassee, they will pretty much, streamline you back to me. So it's okay to call and check on the status of your claim. You can use snail mail, but I don't really encourage that because a lot of times things get lost. In Tallahassee, they get hundreds and hundreds of applications each and every day. So I don't want a victim to miss out because it got lost in the mail. This page here is where you could locate our application as well as find out about the property loss, the domestic violence relocation, sexual battery, forensic examination information, as well as sexual assault relocation. I encourage you to go to our website, read up on the information that's there, educate yourself on this, and hopefully you can educate others. Thank you.
Thanks, Yolanda. Next, we have Craig Jordan, who's going to talk to us about crime scene cleanup.
Thank you. What I'm going to talk about today is not one of the most pleasant subjects, but it's an important subject a lot of people don't know about, and it's crime scene cleanup. You know, I like a lot of us sitting out there, I like to watch Law and Order and all the CSIs and Criminal Minds, and, you know, they come in on the crime scene and they get all the clues, and by the end of the hour, it's wrapped up and, you know, he's either in court or behind bars. But they never cover who cleans up the crime scene. So this is crime and trauma scene decontamination services. They would include cleaning and the restoration for families and businesses that have a need for a biohazard contaminant cleanup to be cleaned and removed from their living and or work environment. This main focus is around homicides, suicides, human decomposition, and gross filth situations. Most of the work is based on a death incident and would involve blood and body fluids to be cleaned. Who does it? That's the big question. Everybody says, well, doesn't the police do it, don't they? Nope, they do not. Well, the EMS services, they do it, don't they? No. Well, the funeral homes, they do it. No, they don't. Who do I need to contact? Well, the most important thing to remember is that you need to contact a qualified state and county permitted company to do the cleanup and removal. The permits are issued for generators, transporters, and storage of the biomedical hazard. Why do I need to use a qualified company? The substances that are to be cleaned and removed are defined as biomedical waste. These also include the materials that you use to clean up that situation. That would include blood and body fluids that are infectious. The state of Florida Department of Health and the Alachua County Health Department, the Environmental Health Section, regulate biomedical waste with the Federal Administrative Code, Chapter 64E-16. All this is we want to make sure that the biomedical waste is cleaned up and disposed of properly and not just dumped in our everyday dumpsters. The code sets the requirements of biomedical waste generators, transporters, and stores. Violations of this code, such as improper disposal, can result in fines and or misdemeanor charges. When you're using a qualified company, you want to make sure that the cleanup is complete and will not present problems for the client in the future. Blood and body fluids can seep into areas that are not visible to the naked eye. They can go under the carpet and the pad. They can go under tile floors. They can go through sofa cushions into the sofa frame. So you want to make sure that it's cleaned up properly, and it can go in the walls in the other rooms without even seeing it. Not only can this blood and body fluid be infectious, but when not cleaned, removed, and sealed properly, they will cause staining and, most importantly, odor. Before being cleaned up, the blood and the body fluids can contain infectious bloodborne pathogens. The most two common that are found in that is hepatitis B and HIV. These are the most dangerous that can be contracted through exposure to the bloodborne pathogen. OSHA governs the cleanup industry, the people that go in and do the cleanup. They want to make sure that the workers are protected from this infection. A qualified company should have their workers in the proper gear. This would be a full suit. It will be gloves. It will be booties. It will be respirators, and it will be eye shields. This is only to protect the worker. And OSHA also requires the company to have all workers on the site have a hepatitis B vaccine. The crime scene is an emotional event. That can be traumatizing for the families and the victims. The families and the victims involved, they're going to have to make some tough decisions. What do they want to clean to keep? What do they want to just throw away? I think this is where victims advocates can be a great help by helping to prepare the families and the victims for these very difficult and emotional questions. And hopefully, by doing that and getting them ready, helps to reduce the emotional stress that they would have. And a properly qualified company, they're going to take the time and the care to make sure they clean up everything. You do not want a family going back into a situation and see something that would remind them of that tragedy. That's how important getting it all cleaned up and cleaned up properly is. Next big question, who pays for this? Most homeowners' insurance policy will take care of this. Always check with your insurance carrier. And also, as Yolanda just mentioned, always talk to your victim's advocate. They may be help in victims' compensation or restitution. So please, if the situation arises, the victim advocate is a nice place to talk. How do I find somebody to clean it up? It's real easy. Google biohazard cleanup in Gainesville. But your local funeral homes will have this information, as well as the victims advocates who are, with several law enforcement agencies, as well as the Alachua County Community Support Systems and their Victim Services and Crisis Center. So we hope we give you some information. Should this tragedy arise, now you'll know what to do. Thank you very much for your time.
Thank you, Craig. Next, we have Barbie Hechevarria with the Alachua County Victim Services and Rape Crisis Center. She's going to talk to us about victim advocates and victims' rights. Thanks, Barbie.
Thank you, Lisa. Good afternoon. I'm Barbie Hechevarria, and like Lisa said, I'm with Alachua County Victim Services and Rape Crisis Center. A lot of the information you'll hear today will overlap each other, so forgive me if I say something that's already you've heard today. Okay. I'm going to talk to you about victim rights and about victim advocates. You've been hearing this word a lot, and you're probably wondering what one is. A lot of the rights and laws that we have in our criminal justice system pertain to defendants, and people who have had crime affect their life wonder, well, what about me? And what are my rights? In the late 80s, this became a big movement, and victim rights under a certain statute have evolved over a certain amount of time. And I'm going to tell you a little bit about that today, time permitting. An advocate is somebody that helps you. A crime victim advocate helps you if you've been a victim of crime. And we have many responsibilities and duties under that title, but mostly we kind of are a liaison between you and the criminal justice system. We do help with some civil matters such as restraining orders or injunctions, but we are there to answer your questions, to provide you with information, to inform you of your rights, and help you through an overwhelming process otherwise. And some of the services that you'll find in Alachua community are wide-based. We have some that are community-based, such as Alachua County Victim Services, and you have Peaceful Pass, which helps with domestic violence, and the Child Advocacy Center. And then you have your law enforcement-based agencies, such as the Gainesville Police Department, the Sheriff's Office, and the University of Florida's Police Department. The State Attorney's Office has advocates as well. And the Alachua County Victim Services will help whether or not you have a criminal case. So that's one difference that our agency offers. You might be asking, well, can I afford an advocate? How much does it cost? It's free. It's absolutely free. And in some cases, some of the information may be confidential. So we are free. Yes, free. And Florida Statute 960, you've heard about today. This is basically the guidelines for fair treatment of victims and witnesses in the criminal justice system. And this includes victims or the next of kin of a homicide victim. And it lets them have rights to be informed, present, and to be heard. So if you don't remember anything else about rights, just remember those three things. When relevant, at crucial stages of a criminal proceeding, to the extent that the right does not interfere with the constitutional rights of the accused. So what rights are victims entitled to? You'll see one word on here a lot, and that's information. Information about services that are available, information about the role that they have to play in proceedings, information concerning the steps that are available to law enforcement officers to help protect victims from intimidation, information concerning the escape of the offender. And the VINE system that was mentioned earlier is a really good thing to sign up for if you have a suspect in a case that has been arrested. So I did not list every right. There are many in this statute. I tried to highlight the main words. So some of the rights continued. Okay, let's go back. Our advanced notification. You have the right to make a victim impact statement at a sentencing. You have the right for your PowerPoint to work. All right, go back. It's not advancing. You have the right at a deposition to have a victim advocate present, and you have the right to, in advance, be notified of every crucial stage by letter, usually from the state attorney's office. You may, in addition, have a victim advocate, if you're working with one, calling you or sending you letters as well. A victim impact statement was mentioned briefly, but this is basically letting the court know that this crime has affected you emotionally, physically, financially. It brings a lot of peace of mind for people and closure. You have the right for victims of domestic violence to have your address be held confidential in certain circumstances. Restitution will be discussed later, but it's important to let the state attorney's office know if you do want restitution, if you're eligible in your case, the return of your property after it's been collected by law enforcement. In felony crime, consultation by the state attorney's office to obtain your views. You are important. Your views do matter, and you should have some input as to this affecting your life and what you would like to see be the outcome. And along with rights, there are specific rights for sexual battery victims. Victims may be examined by a registered nurse or a doctor. In Alachua County, they would be taken to Shands Hospital at UF. At any point, you can say no to any part of the exam. The exam can be confidential. You have the right to have an advocate from a certified rape crisis center with you. The exam is free, whether or not you want to continue with pursuing criminal charges. Anyone who has been the victim of a crime of a sexual nature needs compassion, sensitivity, understanding, caring. We have a hotline 24 hours a day. We have rape victim advocates. We are available free of charge, and we are there afterward as well to help you continue whether or not there's criminal justice in your case. As you see, sexual battery victims have a lot of specific rights as well, and some of it is similar to general crime victims, but for instance, the offender, if charged, can be tested for HIV and hepatitis. To have the advocate at the exam, like we said, to have information, their identity, that the confidential information, that aspect, that can be kept exempt from public records. To attend the sentencing or disposition of the offender and request that the offender is required to attend a different school if the offender goes to your school or your sibling's school, to have the courtroom cleared during certain processes, to not be asked or required to take a polygraph exam, to take up to 3 days of leave from work, and there are certain restrictions. And if you fear for your safety, you can seek a sexual violence injunction or restraining order, and those will be covered later on today. If you also fear for your safety, you may be eligible for relocation. For more information on our services at the county or for any of the other advocacy programs in our area, please feel free to contact the Alachua County Victim Services and Rape Crisis Center. We also have a website, and like us on Facebook. Thank you.
Thank you, Barbie. We're going to take a 10-minute recess to go ahead and set up for our next presentation. There are bathrooms located right across the hall from the main door you guys came in, and we'll see you back in about 10 minutes. If anybody has any questions that are available, we'll be happy to pick those up. If you'll just kind of hold them up, we'll have somebody come around and get them. Thank you. Next up, we have Molly McGowan. She's with Peaceful Paths, and she's going to speak to us today about restraining orders. Welcome, Molly.
Thank you. Okay, whoa, I'm short, sorry. I'm here today to talk about different legal options for people who have been victims of personal crime. In other words, someone else has caused an injury to them, not a corporation or anything like that. And the first thing I'm going to talk about is, if I can get that going, there we go. What is a protective injunction? There are different kinds of protective injunctions, and a protective injunction is basically what most people call a restraining order. You know, we have a lot of people who come into the courthouse and they're like, I need a restraining order. And then when they get the paperwork, they ask me, what is this? And I'm like, it's the same thing. But the state of Florida calls it an injunction for protection. So that may, so that will help you understand a little bit what I'm talking about. Okay, now I've lost my mouse. There we go. Okay. There are 5 different types of injunctions. The most common one and the one we see the most often is called a domestic violence injunction. It's the one where if it's your spouse, ex-spouse, someone who you've been living with, have a child with, or another family member who you have lived in a home with, that would be a domestic violence injunction. And the types of injunctions are mostly determined by what your relationship with the person is. So that's why there's different types. There's the domestic violence, and the advantage to the domestic violence injunction is that you can get custody of a home if you share a home. You can get custody or time sharing with the children worked out, support issues. They can add other addresses. So that's the difference. When you come down to the courthouse to file an injunction, what you would do is go into the clerk of court's office, and they would ask you a series of questions, or if you're working with a victim advocate, they'd ask you a series of questions and to try and determine what is the correct set of paperwork to give you. Why get an injunction is to obtain legal protection against contact from the abuser, to prevent further harm to you. You're basically trying to just keep this person away from you so that they can't hurt you anymore. It's legal protection. It gives law enforcement a little bit extra to be able to keep you safe. And an injunction for protection is not the same as the no contact you would have in a criminal case. When someone is arrested in a criminal case, there is a no contact put into effect usually at first appearance by the judge as a condition of their release. And it says, okay, if you are released, you can have no contact with the victim in your case. This is not only to prevent further harm to this person, but to prevent witness tampering and things like that. It is not the same thing as a restraining order or protective injunction. Okay, there are different things that can be done with each, and we're going to go over those. Injunction for protection is a civil order, and the person who is asking for the injunction must come down and ask for it. It is not automatically entered if you're a victim of a crime. So that's one major difference, is because the no contact is put into a place by the judge. Here's a list of differences. The injunction, you have to apply and explain why you are in fear of this person. What have they done? You are given or mailed an official copy. It may include the home. May order some kind of assessment for mental health or other type of counseling for the abuser. Can include addresses other than the home. In other words, if you work and you don't want this person coming to your work, or the child's daycare, or other family members' houses, things like that. It also makes it illegal under both state and federal law for the respondent to own or possess a firearm or ammunition. The no contact, the judge orders at first appearance. The victim usually does not have a copy immediately, which can be a problem with enforcement for law enforcement. It may include the home they shared. That is up to the judge, and the victim may not know if they were not at first appearance. It may be dropped with little to no warning to the victim. If the case, for whatever reason, is dismissed, or they suddenly plea out, or if the victim has moved and has not been in contact with the state's attorney's office, something may happen in the criminal case that they won't know about. And the no contact part, if they plea out and they agree to probation, the no contact may or may not be part of that. They may think they still have a no contact when in fact they don't. It does not include other family members or children, and ends at the resolution of the criminal case. Basically, if you want an injunction, the best way to go about it is coming down to the Alachua County Civil and Family Courthouse Monday through Friday from 8 to 5, and filling out the petition there. If it's a night or weekend, in an emergency situation for domestic violence, you can go to the sheriff's office and ask them to help you file it, or call the Combined Communication Center and talk to them about it, because the sheriff's office is not open 24/7. So make sure that they have a deputy that can meet with you. It is state law in all counties. There is some kind of protocol to get an emergency injunction, 24 hours a day, 7 days a week. So if you're in an outlying county such as Bradford or Union, you would need to contact your local law enforcement and find out how they do it there, because each county covers it a little bit differently. You will need, one thing that we have run into is you will need to have the abuser's information, their date of birth, and an address so that they can be found for service. If they are running or they are trying to avoid getting arrested, they're going to have the same problem serving them with the injunction as they would arresting them in the criminal case. And the injunction is not in effect until the person is served. I put up some tips here on different things to do with an injunction. It's just things to put on like if you're concentrating on acts of violence, don't put, this person hit me. You need to be specific about where they hit you, what they hit you with. If they were making threats, what the threat was, not just say this person threatened me. And there's a whole, list of things on here. Any incidents that you want the judge to consider need to be put on the petition. You can't come into court later and say, well, there have been other incidents that I want to tell you about. The judge will not be able to hear that. The judge has 3 options. The judge can grant the temporary injunction and set a hearing. The hearing is to give the respondent a chance to defend themselves. The second option is the judge can simply set a hearing without granting an injunction. That can be a safety issue, but it does happen. If you're going to do an injunction, I would ask that you try and get a hold of an advocate. The third option the judge has is to deny the petition and explain why. They have to put in writing why they're denying it. If the injunction is granted, a copy of all of the paperwork is served on the respondent. That is when the injunction goes into effect. So you also need to be aware that the respondent, the abuser, gets a copy of everything you've written. So if there are things in there or addresses in there that you don't want them to know about, you either need to just simply leave it out of the paperwork or ask for a confidential address. There is no fee associated with filing any kind of injunction. You can file for it in any circuit. In other words, if the violence happened somewhere else and you have since moved to be with family or friends, you can file it either where you are, where the violence happened, or where the respondent is living. So, if you need to leave for safety reasons, you can file it once you get to the place where you're going. Neither side is assigned an attorney by the court. If you feel you need an attorney, you will either need to apply to legal aid or hire one on your own, and that applies to both parties. One thing to keep in mind is an injunction or no contact, and neither are a guarantee of safety. Please get a hold of an advocate, do a safety plan, and keep in contact with law enforcement and the state's attorney and everyone, because in the end, both of those things are just a piece of paper and they're not a magic shield. So what they do is they help give you legal protection and expand what your options are. Okay? And I was also going to go over filing a violation. Obviously, if the person is there in person, call 911. Don't call me and say, they're here. And I'm like, no, I'm not here. I can't come out there and do anything about it. Please call 911. If possible, they'll arrest the abuser. They will also do a violation. If the violation is an indirect, like telephone call, text, or something like that, which we see a lot of, the report will be sent to law enforcement, the state's attorney, and the judge, and they'll set up court hearings to determine what to do with it. If law enforcement can't do anything, you come down to the courthouse and file a violation there. Put as much information as you can on it, and then the judge and the state's attorney will decide what the best course of action is. And then if you want to look at the injunction paperwork, actually, I have the link here. The Florida Courts website has 4 of the different types of injunctions online. It does not have the cyber stalking and the stalking one yet. If you search the Florida Senate, you can find it, but it's not online yet and able to be filled out. The other 4 types of injunctions, you can actually go online and fill out and print and then bring down to the courthouse. And there's the clerk of courts and the sheriff's office information there. So, all right. Okay.
Thank you, Molly. Next, we have Deborah Hunt. She's with the State Attorney's Office. She's an attorney with them, and she's going to speak with us today about how to recover property that's been stolen and pawned. Thank you.
Good afternoon, everyone. My name is Deborah Hunt, and I'm an assistant state attorney with the state attorney's office here in Alachua County. I'm here to talk to you about how to get your stuff back if it has been stolen and pawned and given to a pawn shop. Thankfully, our Florida legislature has sought fit to make sure that there's a process in place so that if your property has in fact been stolen and pawned and you want to get it back, you do not get re-victimized by having to pay for your property. So, specific steps you can take. Number one, look at the pawnbroking statute. We also have brochures, which are available at the state attorney's office. I have a couple copies here today. It is basically an outline of the procedure I will explain here today. And here it is. Here is basically an outline of the procedure a citizen would need to follow to get their property back. First of all, you can look at Florida Statute 539.001 of the Pawnbroking Act. Your first step is that you or law enforcement needs to identify the items at a pawn shop that are stolen belonging to you. So this can be involved in a couple of different ways. Number one, you as a citizen can go to local pawn shops to find out if your items are there, or you can call law enforcement and file a police report to determine whether they are there. Law enforcement has search engines that allow them to search databases of pawned items throughout the state. So they may be a more efficient resource for you, and I would encourage you to use them. Second step, you as the victim would need to send a certified letter with a return receipt to the pawnbroker, or you can go to the pawnbroker personally and have them sign a written receipt with a letter claiming rightful possession of the item. There is wording in the brochure that you can use as kind of sample wording that you can use as standard vocabulary to help get your items back. You must provide a clear and accurate description of the item and include the police report. So this is very important. You have to be able to report this to the police in order to get your items back. You can't just walk into the pawn shop and say, hey, that's mine and it's stolen. Obviously, if for personal reasons you are unable or unwilling to make a police report, you are always welcome to buy your items back from the pawn shop, but of course that means that you have to outlay the money personally. If you are the victim of a crime, the police have given you a report, you have laid out a detailed list of the items stolen, then you can put that information in the report. Now, the question that I would think to ask is, my house was broken into, a whole bunch of stuff was stolen. I told the police about everything I could think of at the time. But after they left 2 days later, I looked in another drawer and I realized more jewelry was stolen, or this item was stolen. What do I do? You call law enforcement back, ask to speak to an officer, and get them to make a supplemental report or an addendum to your police report. They are more than willing to do that. That is a normal circumstance that they encounter every day. That way, even if in the original police report you did not list those specific items, you can still get them added and still get a copy with that supplement. So you've written your letter, you've sent it certified, you've included a description of the items in the police report. Now what? The victim and the pawnbroker have 10 days from receipt of the above-mentioned letter to work out the return of the victim's item. What that means is, if the pawnbroker believes that you have sufficiently described the items, they've been shown the police report, they should give it back to you. They should give you the items back free of charge. And then the pawnbroker becomes the victim for the police report, and they become eligible for the restitution since you have your items back. Now, obviously, if there are more items in your police report than there have been pawned, you would still be owed restitution for the remainder of the missing items. But for the items at the pawn shop, the pawnbroker would then take over as the victim for restitution purposes. If there is a conflict in what they believe you have, or sometimes they are unwilling to return your items, then there is more that can be done, and we will click to that right away. If the pawnbroker refuses to turn the items to you without consideration or payment, you can go to the civil courthouse and file what's called a writ of replevin. This is basically paperwork that you're telling the court, this pawnbroker has my items, they are unwilling to give them back to me even though I've shown them that they are stolen and it is mine. and you are now filing basically a little miniature lawsuit with the court. Once you file the writ of replevin and serve it on the pawnbroker, they must hold your items. Now, most pawn shops have a hold period specific to the pawn shop. I believe it's 60 or 90 days. So there's a time frame that they're required to hold the items to begin with. So time is of the essence. The minute you realize your items have been stolen, you need to start this process, because after 60 or 90 days, your items may not be there to even go through this process. But once they are served with this writ of replevin, that 60 or 90 days stops until this issue is resolved with the courts. So they are not allowed to then sell your items or return them to the pawnee. So they're holding the item now because you filed your writ with the court. And it should be noted that just like injunctions, there are no filing fees at the time you file your suit for writ of replevin. No filing fees, no service fees. Everything is free to you, the victim, up to this point. So then the court will give the pawn shop time to respond. At any point in time, the pawn shop can agree to settle and give you your items back. Once that happens, obviously your suit becomes null and void. But if they do not agree to give your items back, the court will then hold a hearing to determine whether the property should be returned to you. If you prevail at the hearing, the pawnbroker has to return your stuff and pay all costs associated with the replevin, all the filing fees, all of the court costs and everything. Now, if you have not complied with the appropriate pre-replevin hearing procedures, or the court finds against you, you then may have to pay the pawnbroker's legal fees and court costs. Now, I will say if you follow all of these items in turn and you have your specific description of the items, you've had your police report and all of your ducks in a row, this should not be a problem. I say should not, I cannot say will not. Now, the state attorney's office will most likely be involved in your case in some way, shape, or form, assuming we can determine who the perpetrator is. Law enforcement agencies and our office, the state attorney's office, shall promptly return a victim's property if it's held for evidentiary purposes unless there's a compelling law enforcement reason for retaining it. Well, what does this mean? Well, sometimes the property and evidence at the pawn shop becomes evidence at our trial that we need to use. And it comes into the sheriff's office custody, and then it comes into the clerk's custody or the court's custody during a trial. We can request that you get your property back after the case is closed and after it's no longer needed for evidentiary purposes. So please don't be afraid to ask us. Let your victim advocate know that you want your property back. Let your state attorney know. Let the deputy know. There are lawful ways for you to get your property back, even if it does become evidence. So if you want your personal property to be returned to you, ask your prosecutor. That's what we're here for. Last little bit, dealing with restitution. Florida statute 775.089 provides that in addition to any other punishments, the court must order a defendant to make restitution to a victim for any damage or loss caused by or related to the defendant's criminal offense or criminal episode, unless the court finds clear and convincing reasons not to order such restitution. So, again, in that burglary situation where you've had a number of items stolen, maybe only a couple of them are pawned, the remainder of which you're entitled to have restitution for. And the way that works is you submit receipts for your items or best guess cost estimate for your items, assuming sometimes we have antiques and things where it's really hard to determine a value, to the state attorney's office. We will then make a presentation to the defendant and his attorney with these items. We will try and work out an agreement. Sometimes the agreement is exactly what you've asked for, and we'll work it out with you. And then it becomes a judgment or a civil lien that the defendant has to pay that could either be just a part of his record or her record, or it can be a part of his or her probation that he has to pay back over the course of probation. If we cannot come to an agreement, then we held a restitution hearing in front of the court, where we have to put on evidence that these are your items and this is what they're worth. And you may be asked to participate in that hearing. We also may have experts come and testify at the hearing in terms of valuation, and then the court makes a decision as to what you're owed. But I think that essentially covers recovering stolen pawn property and stolen items. Please don't be afraid to stop by the state attorney's office and get a copy of our brochure and look at the steps here. They're also listed online on the state attorney's website. You can go through and look at all of those steps. Thank you very much.
Debbie. Gretchen Casey is going to speak with us today about appellate crimes and restitution. Gretchen is with the state attorney's office as well.
Good afternoon. I'm going to touch on just a couple other points that Deborah Hunt started with. And what I want to talk with you about is the right to request restitution. As Ms. Hunt explained to you, it's really, really critical that as soon as you make contact with the state attorney's office or with your law enforcement agency, that you make sure that you point out if you have restitution. That could be lost wages, it could be medical bills, medical related expenses, it could be for property damage or property replacement. And so it is absolutely critical that when you meet with our office that you let folks know, either through your victim advocate or with your assistant state attorney, that there is restitution that you very much are concerned about getting reimbursed for. Now, we can always ask for restitution. The ability to ensure that it will get paid back or paid back in a timely manner is a separate matter. And a lot has to do with the defendant's ability to pay and whether or not they're going to be sent off to prison and whether or not they have any resources. And so those are things that we're going to, as victim advocates, be talking with you about. So there's the issue of ordering the restitution, and then there's a separate issue of collecting it. There is one particular area where the state attorney's office does get very, very involved with restitution, and that is when the defendant is a juvenile. We have a program called Project Payback, and we have a particular victim advocate who works directly with victims in juvenile cases. And what she'll be specifically doing is absolutely getting all of that restitution information directed to the assistant state attorney. And in juvenile cases where the defendant has not reached their 18th birthday, what we do is we order the restitution and then simultaneously order the individual to participate in Project Payback. And that's a program that specifically looks at increasing the likelihood of returning restitution to victims of juvenile offenders by giving them the option of working off their restitution. We have a pot of dollars. Again, it's only available in juvenile cases where restitution is ordered, that we have the ability to both monitor and hold in contempt those juveniles that choose willfully to disregard their restitution obligations through a restitution order. But again, that is only in juvenile cases. The other way that we can, what I want to make folks aware of is that if you receive a letter from our office, or if you're working with a victim advocate and you are a victim of a crime and you are asked, please turn in restitution estimates, that's really, really critical, because sometimes we have a very small window in which we can ask for restitution. So as quickly as possible, let your victim advocate or prosecutor know that you expect or anticipate that you're going to have expenses. Maybe it's for reimbursement of a or repair of a damaged item, or maybe it's the cost of replacing a window. Even if you only have an estimate and you've not actually had that property replaced or restored to its previous condition, it's really important to let the state attorney's office know that you will be submitting restitution estimates. That is the only way that we can assure that it's taken care of. So if you get that letter, the most important thing is do not postpone or delay getting your restitution estimates to the prosecutor's office. So, you've heard a lot today about how the system works and how victim advocates can assist people throughout the process. And many times what happens is for individuals who have gone through a trial process, they finally believe, okay, it's over. It's finally done. This chapter is finished. We've gotten a trial. Hopefully we've gotten a conviction. There's a sentence. And the defendant is either going to go off to jail or serve a term of probation or perhaps go off to the Department of Corrections. The thing that we need to point out and make victims and survivors and families aware of is that many times the trial court may essentially be over and victim advocates and families may feel like we're done. But the reality is that every single person who is convicted of a crime here in the state of Florida has a right to appeal their sentence and their conviction. And in that case, then what happens is an appellate process takes over. And that appellate process may not always involve victim advocates locally. Many times what you'll find is that the Attorney General's office has a staff of very, very well-trained specialists in the area of appellate law. And because there are 5 district courts of appeal, it may not be a local victim advocate that begins helping you, but it's in essence, we turn the case over to a victim advocate who is especially trained in those issues. And what will happen is it's in some ways a pretty complicated system. So I'm going to just give you sort of the beginnings of the appellate stages and what will take place, and then assure you that an appellate victim advocate will be available to work with you in sometimes the months and years that it takes for an appellate case to be reviewed and decided upon. So the way to perhaps best look at this is, oops, here we go. Let me get us caught up. Perhaps the way to start about this is to understand what an appeal is. And an appeal is essentially the method that a defendant has, who's now a convicted felon, to raise questions about the validity of either their conviction or their sentence. And the critical sort of time frame to understand is that when we're looking at appellate cases, a defendant has the right to file a notice of an appeal within 30 days of the sentence, all right? The conviction and the sentence. And what they're going to do is they're going to file a written document, and this written document is referred to as an initial brief. And what the defendant or the defense attorney cannot do is simply say, I want to re-argue the evidence of the criminal case. I want to re-argue that. I think if I emphasize this point or that point, I can get a new trial or a new sentence or a different sentence. But what they have to do instead in this initial brief is they have to cite some legal error or some similar basis for the appeal. And when that happens, the appeal is going to be sent to the Office of the Attorney General. The only way the Office of the Attorney General is going to be able to then notice you of what's going on with the case is if they have your correct and current address and phone number with the state attorney's office. Every single Tuesday morning, I get notices from the Attorney General's office asking for all the contact information that we have within our files that we can then send up to the Attorney General's office so that those appellate victim advocates then can begin contacting, in cases of children, it would be adults or guardians, but in other cases, it would be the direct victim to advise them that a case has, they've received an appellate or initial brief on a case. When those appeals are heard and when a victim advocate from the Attorney General's office would contact you, understand that simultaneously what's going to take place is that these cases will be heard before a panel of judges. Now, even though we have between anywhere from 9 to 12 or 15 judges, typically in any case review, there's only going to be 3 judges that will actually hear the initial brief. And these are not going to take place here in Alachua County. They're going to take place at a district court of appeals. And so the vast majority of victims probably will not be involved in these types of cases unless perhaps it's a homicide or a very, very serious case. But you certainly can be as involved as you choose to. And your victim rights that we've discussed and talked about and that Barbie covered are certainly extended to the appellate process as well. The most important thing is to let you know that even though those of us locally may not be specialists or experts in appellate cases, that there will be someone who is a specialist from the Attorney General's office that will be happy to answer questions, guide you, and if you choose to accompany you to those hearings. Again, the most critical piece is that should your information change from any point, from the point that you contact the law enforcement officer or at the point that you become involved with the state attorney's office, it's absolutely critical that you let the state attorney's office know if your phone number, email, or address changes so we can keep that information up to date and allow you to be informed all the way throughout the court process.
Thank you, Gretchen. Next, I'd like to turn your attention to our panel of professionals within our community, and they're going to speak with us today about some specific services and programs that are available in our community. Thanks.
Hi, my name's Teresa Drake, and I'm the director of the Intimate Partner Violence Assistance Clinic, known in the community as the SOURCE program. And we are a free and confidential service provider for victims of dating violence, domestic violence, or sexual violence. We have a multidisciplinary team, so we can provide legal services, counseling services, and victim advocacy case management services. So, for example, we may have a client that calls us and is interested in getting an injunction, as Molly talked about earlier, or has questions about child custody, or has questions about immigration. Perhaps they're a victim of domestic violence, but they are undocumented in this country, and they're afraid for their safety, and they don't know where to turn. The SOURCE program is located in the Levin College of Law here in Gainesville, and it's actually a class at the law school. So the legal representation is done by third-year law students who have special permission from the Supreme Court of Florida to practice law under an attorney's supervision, that attorney being me. So not only do clients have a law student and myself involved, but with the victim advocate and the licensed clinical social worker, a victim has a team of support behind them. The licensed clinical social worker can provide counseling services, and the victim advocate case manager can provide victim advocacy during court processes or any other life-changing events that the victim is going through, may help a victim acquire food stamps or get through whatever community resources they need. Each individual victim is different in terms of what their life circumstances are, but try to rally community resources so that victim has whatever needs we can meet met. So one of the things that is required before a victim can get services from the SOURCE program is that the victim be indigent. Indigent technically means 200% of federal poverty guidelines. Indigent in reality is most of the victims that call our office, because when we're doing the indigency inquiry, we look at a victim's her or his own assets and own income. So it's not the assets and the income of their husband or their wife or anything that they own jointly. It's what the victim has, him or herself. And then whatever children they're caring for are added as dependents. So it's really pretty frightening how quickly victims can meet indigency status when they are separating from their partner, their husband, their wife, and they don't have the assets or the salary to be able to pay for an attorney or get an apartment or sometimes even food for their children. So we can help with all of those things. Our number is 352-273-0805. And during working business hours, you'll get someone from the SOURCE program answering the phone. After hours, we transfer our phones to the Peaceful Paths hotline. You'll hear from Teresa Beachy in a moment. And a victim advocate from Peaceful Paths will be answering the phone. So a live person will be answering the phone 24/7. So if a victim calls and has questions, has concerns, feels that they're in immediate danger and need a place to go, this number will get you someone to talk to that can meet your needs 24/7. Thank you.
Good afternoon. My name is Sherry Kitchens. I am the director of the Child Advocacy Center in Alachua County. At the Child Advocacy Center, we provide a child-friendly location for the response to child abuse investigations. In our community, we have a number of amazing, wonderful, both governmental and non-governmental organizations that work to help protect children, and we help provide the coordinated response to multidisciplinary team efforts to help keep children protected. At the Child Advocacy Center, we provide child-friendly and child-trained forensic interviewer. At the center, we provide forensic interviews in that child-friendly setting where the multidisciplinary team watches the forensic interview through a closed-circuit television. A multidisciplinary team of professionals at the Child Advocacy Center can be Department of Children and Families, child protective investigators, can be law enforcement, can be a state attorney, an assistant state attorney, can also be a guardian ad litem, a family care counselor, and a therapist working with the child in various capacities. We recognize that child abuse investigations are very stressful for families and for children many times. And so we hope to provide that insulation for children going through the process. We feel like they really deserve to continue to be children and not have to deal with the adult part of the investigative process and the information gathering process to make sure that the children are safe. We also provide case management and advocacy services at the center, and case management can be anything from food, clothing, housing, shelter, mentoring, linking a family with mental health services, making sure that medical services happen appropriately. We also provide play therapy at the center for children who are beginning that healing process. Our services are free of charge. We also provide support to the non-offending caregivers at the center by providing an advocate to help them through the process, to help them understand who all of the different folks are that are intervening in their family, as well as providing a non-offending family member support group to help them understand what the red flags are, what they can do to help keep their children safe, a place to have others to talk to just about what they're going through. We also provide group therapy for children who have been physically abused and sexually abused. Part of the procedures at the Child Advocacy Centers include looking at everything through the eyes of the child. And so we pay particular attention to what their experience is like, what they tell us. We want to make sure that they have a safe place to disclose, to tell us about what's happened. It's also really important to learn if nothing's happened and the allegations that have been brought forth are not warranted and that the child is in a safe environment. We provide that support all the way through the process. We keep our cases open and provide that support until all of the other agencies have closed their cases and the family doesn't have any other needs. Like I mentioned before, our services are free of charge. We also have the opportunity to be involved with the children through the therapy process as long as they need us. So there's not a limit on the number of therapy sessions the child can come to. We also provide a certain amount of training to the community to talk about what risk factors are, protective factors. We talk about how to keep children safe. We do training on internet crimes against children, also drug endangered children, and child abuse reporting. We provide training also to the professionals that work with child abuse victims in our community. If you are in need of an advocate, we have 3 advocates at the center that work with children. One that works specifically on the criminal side of child abuse cases and works specifically with the state attorney's office, helps with testimonies and depositions if a case were to move forward that way. We also have an advocate that works to ensure that all of the services that the child is referred for, that they're actually able to get those services and make sure that all of those services are actually attained by the child and by the family. So it's not just, here's a phone number, call these folks, but let's make sure that we actually get you to that place and you get the appropriate service that you need. We're very fortunate in our community to have work with a number of just amazing victim advocates across this community, and we work very closely with them to make sure that everyone's getting, the children and the families are getting everything that they need. So we appreciate their partnership and hope this has been helpful to you today.
Good afternoon. I'm Dr. Teresa Beachy. I'm the Executive Director at Peaceful Paths. We are the state-certified domestic violence center that serves Alachua, Bradford, and Union counties here in North Central Florida. We provide free and confidential services to adult and child victims of domestic violence, everything ranging from a 24-hour helpline to emergency shelter, transitional housing, victim advocacy, counseling and support groups, trauma-related therapy, the partnership with the SOURCE program, violence prevention programming, rural outreach programming, and a wide variety of individual services for victims and their children. Our organization is very unique in this community because we are the only victim advocacy component that also provides residential services. So for those victims who find themselves in an immediate danger situation and they need to leave their house because the partner is threatening them, or they are just simply not safe in the living situation that they're in, those victims of domestic violence can call us and screen for shelter at any time. As Teresa said, our hotline is answered 24 hours a day by a live trained individual who can not only deal with the crisis at the moment and do some safety planning, but can talk to you about what other services you might be eligible for or things that are available for you and your child in the community. Most people think of emergency shelters as kind of an institutional setting where maybe you think of something that you would see in terms of an emergency shelter associated with a hurricane. I can assure you that our shelter is very different. It's very much a home. We have 30 beds, and the women and children that stay there can stay up to 6 weeks as they're transitioning out of the violence in their lives. Some stay longer. Our average length of stay is about 3 weeks. And while they're there, we work on a variety of things with them. A lot of people come in and really just want to reconnect with family. So we help them do that and reestablish a support system that may have been severed during that domestic violence relationship. They also are often in need of employment or childcare. Housing is often an issue. So while they're there, they work with case managers and advocates to kind of fill in all of those gaps and ensure that when they leave the shelter, they're in a better position to hopefully not only have to not return to a violent situation, but to start moving forward in their life and have a little bit of a new start. If they're not interested in shelter or an immediate danger isn't the situation, they can always come to outreach services. And we see about 750 individuals in outreach services every year. Molly, who spoke a little earlier, talked about the injunction process. We have victim advocates in the courthouse here in Alachua County every day, helping people fill out injunction paperwork and kind of walking them through that process of what they can expect through the court system. We also have counselors available daily in our outreach office where people can come and talk if they have a crisis situation and they're not comfortable doing that on the phone. We also do support groups, about 5 different support groups weekly, both here in Alachua County and in Bradford County and Stark. And those are free and open. We have childcare attached, so if you have your kids, you can bring them with you, and they'll get services at the same time. We also have new services that we started about a year and a half ago for trauma-related therapy. One of the things we know for victims of domestic violence is that while the domestic violence may end and you've got an intervention and you might have stopped the actual incidents of violence from happening, the trauma from going through that can last a very long time. So we have trained clinical counselors who are there to provide free services for victims who are kind of processing that violence in their life and healing from that situation. We find that this is a really beneficial program for victims because not only is it free and confidential, but it goes beyond the traditional support group education that we've been providing for a number of years and really starts to help them heal from the violence that they've experienced in their lives. We are very tied into our community partners. Peaceful Paths is a small organization in terms of the issue that we're dealing with and the amount of staff that we have. We could not do the work that we do without the tremendous partnerships that we have in the community. We have fantastic law enforcement partners in our area who are very committed to understanding victim safety and alerting victims to safety issues as they go out onto calls for domestic violence. We have other victim advocacy partners in the community that we work with to ensure that as a victim is going through the process, whether it's a judicial process or just the process of actually getting over the crime that has happened to them, we make sure that we hook them up with whatever other services that they may need throughout the community. But again, Peaceful Paths is here 24 hours a day. People can access our services through the helpline at 377-8255 or from anywhere in the state at 1-800-500-1119. Again, all of our services are free. They are confidential. They are open to anyone of any gender. We don't discriminate on any of those issues, as well as we don't ask about immigration status or any of those things. The only requirements is that you are a victim of domestic violence and that you are in need of services. So feel free to call us and let us know if there's anything we can do to help.
Good afternoon. My name is Jessie Lazarchik. I'm a victim advocate with Alachua County Victim Services and Rape Crisis Center. So we are a certified rape crisis center, but our program serves all victims of violent crime in Alachua County. We seek to empower victims through compassionate, non-judgmental treatment and uphold their rights outlined in Florida State Statute 960. You heard Barbie cover some of those earlier. We work with both reporting and non-reporting victims, as well as their family and friends. We want to reach out in a culturally sensitive way to men, women, and people of all genders, as well as underserved populations such as people in the LGBTQ community, undocumented migrant workers, human trafficking victims, and those from lower socioeconomic backgrounds. There's no time limit on when you can seek services based on when the crime occurred, meaning if the abuse happened when you were a child, and you're now an adult, or it's several years later, you can still come in for those services. All of the services that our program provides are free and confidential. One of the most important services that we provide is emergency outreach to all victims of violent crime, 24 hours a day, 7 days a week. There's an advocate who will respond when a crime has occurred, either to the crime scene or to the hospital, wherever we happen to be called. And we do crisis intervention. We try to facilitate communication with other people who may be on scene, and definitely working with the victim and their friends and family through that very difficult initial stage. After that, we accompany and support victims through the criminal and civil proceedings. We keep up to date and inform victims of case status updates. We attend hearings with them, and also assist with filing for restraining orders. We offer face-to-face individual counseling as well as support groups. Counseling can be a very powerful part of recovery for victims. We try to help them understand and normalize the trauma response. And just to make a point of this, there is no normal response to trauma. There is no typical expected response. Everybody has a very different response, and so part of it is helping them understand. We want to validate their feelings and also do safety planning if that's necessary. We assist with accessing community resources for the victim. And as Yolanda spoke so well about earlier, we assist with filing for victims' compensation, for medical bills, mental health counseling, lost wages, funeral expenses, or sexual battery relocation. So we help people navigate that process. Finally, we do offer community education and risk reduction presentations. We try to stay away from the word prevention because we don't want to implicate any blame on the victim. It's not the burden of the victim to prevent their victimization, so we use the term risk reduction. So very often we go into schools and give presentations and just try to raise awareness about what sexual violence and crime violence is all about. We have a toll-free hotline that's open 24/7. You can call at any point and speak with a trained counselor. You can also make that call anonymously, and the number is 352-264-6760. Thank you.
Hello. My name is Debbie, and I am one of 2 victim advocates for the University of Florida Police Department. So you now know the face of 50% of my office. And we can assist anybody who has been the victim of a crime, all the way ranging from theft to dating and intimate partner violence to sexual battery, and are affiliated with the University of Florida in any way. So that could be students, faculty, staff, patients at Shands, someone coming to a football game. Really anybody who stepped foot on the University of Florida campus, we can work with. And so we're really fortunate to be that flexible. Our main goal is to not only help someone with sort of addressing their medical concerns and safety and security, but really kind of helping someone figure out for themselves what is the best step for them. We are free and confidential, and even though we are part of a police department, working with us does not mean that you have to report to law enforcement, but we can really kind of help you figure out if that's something that you feel comfortable with and that that's something that you want to do. We also help with liaisoning with all these different University of Florida departments. So let's say a student has been the victim of a crime and has a final exam the next morning. Well, as you can imagine, that would be really tough to try to then go into that exam. And so we can help someone get in contact with their professors and advocate on their behalf to either get an extension or have something worked out for them so that there is minimal stress outside of what's already going on for them. One other office that we work with all the time that I know as a committee we all kind of wanted our specific organization to talk about was the Student Conduct and Conflict Resolution option, which is not a civil and not a criminal justice process, but affects somebody's student record. So if the perpetrator of the crime is a student, student conduct can be a really incredible option for somebody to go through. A very healing process in a lot of ways. It is a very victim-friendly process, which, as we know, a lot of our other big systems like the criminal and civil justice processes can be very difficult on the victim. So I am so fortunate that we have this as an option, and they can do things like establish a no contact or maybe even suspend that student, or expulsion is an option depending on the severity of the crime. We are just so happy to be able to be here for all of you, and please don't hesitate to give us a call at any time. We are in the office 8 to 5, and you can reach us at 392-5648. But between the two of us, we're also on call 24 hours a day. So you can always reach us after hours at the 392-1111 number, which will bring you to the University of Florida Police Department. So thank you so much for being here and for caring. And don't hesitate to call if you need anything or if we can help in any way.
Thank you. And if you guys don't mind staying up there, we're going to take some questions, and there may be something that applies to you. Does anybody have any additional questions? If you do, hold them up and somebody will come around and pick them up. Okay, well, let's get started. Our first two questions actually are going to be regarding victims' compensation. And Yolanda Thompson, I'm hoping you can help us answer those. If you don't mind coming back up. Our first question is, what if the victim is a child and the parent or caregiver has experienced wage loss due to providing care, regarding the incident missing work?
Well, with victims' compensation, we will cover wage loss if it is medically recommended. The doctor would have to give a note to the parent in order for us to even consider paying that portion of it. But it has to be doctor recommended, and it has to be in the capacity that the parent can't leave the child alone at any given time. To give you an example of that, we had a case in Jacksonville where it was a touch and go. The victim was a minor who had been shot multiple times, and the operating surgeon told the parents that they could not leave the property. So the mother was not able to go to work for the next couple days until they felt like that child was out of that danger zone. So in that particular case, that mother was able to file for victims' compensation for wage losses. Again, it's based on eligibility requirements. So if they are eligible, that's one component that they might be able to tap into.
Thanks. And the next question is also for you, Yolanda, if you don't mind hanging. What if the offender is unknown and the case cannot be prosecuted, or if the offender is found to be not guilty?
Well, the great thing about victims' compensation, that piece of the puzzle, we really don't care. And when I say it, don't take it in a sense that we don't care about the prosecution part of it, but whether or not the victim is eligible or not is not based on the offender being prosecuted. So it just is based on if it's a compensable crime. So we have a lot of cases, especially with sexual assault cases, that don't even make it to trial. They're not able to find an offender. So in those type of situations, it's based on was a crime committed.
Thank you, Yolanda. Craig, our next question is going to involve crime scene cleanup. And the question is, would this be covered by most renters insurance?
The typical case probably will, usually renter's insurance is based on contents, because that structure, whether it be apartment or whatever, is owned by the property management company. So renter's insurance, I haven't had a specific case to deal with, but renter's insurance, you may can get some items cleaned, clothes or stuff like that, but it would not cover cleaning the place you live, the apartment or whatever. That falls back, if you're renting an apartment, that falls back to the property management company.
Thank you. Our next question, Gretchen. What is the process once a formal complaint is filed against the state attorney's office for a violation of victims' rights?
Well, I believe that an individual could go to the office of the Attorney General and state some sort of right has been overlooked. If that were to take place, when we've gotten concerns expressed about our office, this is something Mr. Cervone in the State Attorney's Office takes very, very seriously. And generally what happens is we receive some sort of a notice from the Attorney General's office, usually by email, informing us that there has been a request or a concern expressed about something that took place in our office. It then goes from Mr. Cervone to myself or the attorney involved, and we will look into it because we take these matters very, very seriously. What I would say to anyone, if they feel their rights have been overlooked, is immediately speak with your victim advocate. Immediately let your victim advocate know, I believe that I haven't been heard, I wasn't allowed to give input, I wasn't allowed to be noticed or informed or present. Those are the types of things that if you're working with a victim advocate, it's imperative that you let them know that you feel a right has been overlooked or not, you haven't been allowed to express it. If you're not working with a victim advocate, absolutely come to the state attorney's office and speak with one of the state attorney's office advocates, or ask to speak with me directly so that we can absolutely address it and see if it was simply a matter of misunderstanding, miscommunication, or if it's something that we can remedy very, very quickly. And that's what we will attempt to do. So the most important thing is if you feel a right has not been respected, that is statutorily extended to the victim, or to the next of kin or a guardian in a case where it's a child victim, please let our office know immediately so that we can try to make whatever reparations, whatever we need to do, and address, in fact, if there an error or an oversight has taken place. We want you to bring that information to our attention. We certainly don't want any person who's a victim or a survivor of a crime to feel in some way that they were not noticed, present, or allowed to be heard at any point where the state attorney's office had some degree of control over that.
Thanks, Gretchen. And our last question, actually I'll need Laura Colt, if you don't mind coming back up. And Laura, the question is, what other actions can be taken when victims are treated unfairly by police and or the state attorney's office?
Well, so I'm a victim advocate with the Gainesville Police Department, and we, like Gretchen mentioned, we also take complaints very seriously. The process would be to go to the police department and fill out paperwork that you would have an ability to state any actions that you felt that an officer did or something that they didn't do that you felt needed to be done or was mishandled. Certainly, I mean, and so that would be if the person felt that a step needed to be taken for an internal affairs investigation. Sometimes people are familiar with that term, with that office, internal affairs, within every police department, or I believe sheriff's office probably has that. So it would be routed to internal affairs, and they would do an investigation. Now, certainly, if you're on scene, if you're dealing with an officer and you're concerned about communication breakdown or some issues, every officer has a patrol sergeant or a lieutenant that would be on duty, that would be able to be called and asked to come out on scene, or be called to consult by phone or immediately after. So, if something's going on right then and there that you feel like you want to try to get someone higher up, certainly you can make that request, and that would be a call. You could ask the officer if a sergeant could come out. You could put a call into communications 955-1818 and ask to speak with a patrol sergeant that's on duty, and maybe talk a little bit about your concerns right then and there. Thanks.
And that concludes our presentation today. If anybody has any additional questions, please know that every victim advocate within our community works very closely with one another, and we'll do the very best we can to either help you find the information you're looking for or get you in touch with somebody who might be better able to do that. Additionally, there are some bookmarks that are available as you're approaching the door on your way out. There are some bookmarks that are available that contain all the contact information for the agencies that we talked about today. Thank you again.